Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, we do bring in immigration updates. Well, what do you have today to discuss?
Today, we're going to talk about the expected first travel ban of Trump 2.0. We are expecting a travel ban specific to certain countries. So we'll talk about what that country list looks like and what happens when there is a travel ban in that situation. And we're also going to talk about this case of the green card holder who was detained by ICE after some activity involving some protests and things. And, it really captured the media and has a lot of other green card holders scared that, well, if they can detain this green card holder, are they going to be trying to detain others? What to know about it, what to be concerned about. And then we'll talk about FDNS, fraud detection, national security site visits. These have been going on for years and years and years, but they are increasing. We're hearing about them more and more. What to be aware of with that, what's changed from before. And then lastly, we'll talk about when you are switching H-1B employers, filing an H-1B transfer or change of employer petition, what should you be aware of? What should you make sure you're in compliance with in the new Trump administration?
Emily, as we know that we had a travel ban before, right now, based on the information that we have, and the Trump administration has been telling that he's going to do a travel ban, it looks to be that 43 countries were been shortlisted. It's not official yet, but most probably. They have been categorized into red list, they have been categorized into orange list, they have been categorized into yellow list. The red list seems to be the complete bar on the people for them to come into United States, and they may not be able to extend or even change their status or adjust the status in United States. It seems to be for the red list. The red list countries includes Afghanistan, Bhutan, Cuba, Iran, Libya, North Korea, Somalia, Sudan, Syria, Venezuela, and Yemen. I don't know why they included Bhutan, which is a protected state of India, but definitely India and China is not in any of these lists, guys. So please be assured that India and China is not in the proposal of any of this. This is the red list. In the orange list seems to be that these people may have very many restrictions. There may or may not be a complete bar, but there'll be a lot of only necessary people may be allowed to come into the country. The list includes Belarus, Myanmar, Laos, Pakistan, Russia, Sierra Leone, South Sudan, and Turkmenistan. And of course, there's a next list, which is the yellow list. Mostly these countries are from African and South American countries. Most of these countries are where the US thinks so that they're not cooperating with US in intelligence, and some of these countries are issuing passports. Like, for example, certain Caribbean countries, they issue passport just by paying a little bit amount. They are issuing passports to the individuals without much screening of those individuals. So there is restriction from these countries. Emily, do you know when this is going to become effect and how devastating it's going to be going forward, though?
It is supposed to be announced in the very near future, from my understanding. We're just waiting any day now. This could be made public and finalized and issued as an executive order. So when we're talking about suspending visas, that typically is going to affect people who are outside the US on the day the travel ban is implemented and who do not already have visas in their passport. And who are from those countries. So for people who are in the US that are from these countries, they should not travel outside the US at this time. But those that are outside the US, if you have your visa stamp, get into the country ASAP, because if you are waiting for your visa, haven't applied for it yet, you likely will not be able to get one. There generally are going to be some sort of exceptions or waivers available that are going to be quite limited and will take time to process. But I think in general, for business immigration, employment-based immigration, this doesn't have a huge impact compared to one of the prior visa bans, the H-1B travel ban that we dealt with earlier. So yes, it is problematic to see any kind of travel bans and restrictions. Makes things very difficult for people, simply based on the country they're from, when they may not have any kind of activity that would cause them to be inadmissible, and there's still potential that they may be impacted and not able to get the visa. But I think the impact to employment based is going to be relatively low.
Emily, so if I have a H-1B visa and I'm from Iran, can I still come back if there's a travel ban?
Um, we'll have to see if anything changes from what was done before, but previously the travel ban did not impact those who had already been issued a valid visa. So they could still travel on that. It suspended the issuance of visas going forward. So people who were applying for the visa were blocked from getting the visa, but those that already had it were able to travel into the US. Now, they may be subject to additional scrutiny and screening at the port of entry because of the country they're traveling from, even if they have the visa already. But based on the past, people who had the visa already were able to travel.
Yeah, at least for those people who are in United States, we strongly recommend not to travel outside the country. And for those people who are outside the country, if we can come into the country ASAP, that would be better rather than look into how the things will proceed because we don't know. I mean, they can change. The previous travel ban had went through some legal challenges. Eventually, in 2018, the Supreme Court affirmed that the administration has the right to do the travel ban. So the Supreme Court hasn't been much changed since the time of Trump has been in power to right now. And if there is any change, that change probably was in favor of Republican Party rather than against Republican Party, though. So we may expect the same results coming from Supreme Court. This administration, Trump 2.0, might extend more, might elaborate more, might put more restrictions than the previous ones. So please keep watching. And if you can not leave the country or if you're outside the country, if you can come into the country, that would be much better. Now, coming to, do you have anything else to discuss on this topic, Emily, before we move?
No, we can move on.
Now, there is a rumor that is flying around. Now, green card holders are not allowed to come into the country. They are being detained, and a lot of rumors are coming, and they have been requesting, they have been forced to cancel the green cards when they entered into the airport. They have been forced to sign a document called 470 to relinquish their green card. How truthful are these rumors, Emily?
I think that they are happening in limited situations, where perhaps they were not happening before, but it is not widespread. We're not seeing this across the board where everyone who has a green card who's traveling into the country needs to be fearful and afraid that they're not going to be let in or that they're going to be told to surrender their green card. I think this is limited to specific situations of, protest activity, pro terrorist organization type of activity, or on the other side of it, people who have spent too much time outside the US as green card holders. Green card is permanent residence. You're supposed to be living permanently in the United States. If you travel, you should be temporarily visiting other countries, but people are staying outside the US for more than 6 months and claiming they live in the US. Well, you're spending half your year outside the US. Of course, it's going to look like you're abandoning your green card. And that is a situation where CBP is really questioning whether you are intending to live in the United States or you're just visiting here and coming back, but staying outside 6 months at a time. Those are people that have had issues at the port of entry. It's probably more scrutiny than before, because people have been likely doing this under previous administrations. But yeah, that is something that they're looking at. So we would recommend not to travel outside the US for long trips if you're a green card holder, and stay away from any kind of terrorist organization promotion activities, I guess. But overall, generally, most green card holders should not have fear of travel right now, unless there's something in their history, any kind of criminal issue, something that would make them inadmissible. Um, Controlled substance, drug violations, those sorts of things. I don't know. What do you think about should green card
Emily,
holders in
I think
general be
so.
worried?
It's been over proportionately been advertised a lot more that the green card holders are getting deported. Not true at all. There's one particular person called Mahmoud, which they seems to be the center of attraction that he was the leader in the Columbia University. In that particular university, at least what the administration is alleging is that there were been pro-Hamas rallies. Hamas has decided to eliminate, they have no compromise according to them. Israel should not exist and they should demolish, they should completely wipe out Israel. So that's a kind of terrorist organization, though. It's not like they're fighting for the territory, but they're also telling that you should abolish a particular country and kill everybody else. So that definitely falls into the terrorist support organization when you are doing a rally. At least that's what administration. I'm not trying to cite this way or that way. I'm just telling what they are alleging. But other than that one particular guy, though, I haven't seen him coming after deporting anybody else. Now that's there's a legal challenge for him. Let's leave that to lawyers and him guys. As far as the common man is concerned, though, if you have any political beliefs, for example, you like Congress or you like BJP or you like a Democratic Party, you like Republican Party, I don't think so. You would be in any trouble whatsoever at all in staying in this country. You be not don't be fearful about it. You can still express your concerns within the legal ways. Absolutely not a problem at all. You can voice yourself in favor of Democratic Party, Republican Party, Green Party, I don't know, Libertarian Party, whatever those parties are, in Indian parties if you want to. Not a problem, not a problem at all. Now, who are the people that should be concerned about? If you have any criminal things, though, even if you have a DUI, you may probably, I mean, if you have one or two DUI, you may want to consult an immigration lawyer. That's one thing that I would say. Anybody who has a traffic tickets, you don't have to worry. But the ones that you have to be, any criminal records other than traffic record, you may want to check with an immigration lawyer. That's one category that I would recommend to check with. The second category to check with is that if you are outside the country for more than 180 days, you should definitely check with an immigration lawyer before you come into the United States. The reason is that, Emily, when you're entering into the country after 180 days, you are required to request for admission into United States. You do not have a right to come into United States, even though you have a green card. And that's where the denials, that's where we are seeing some CBP where they are denying the entries of the people. Now, this used to happen before, even in Biden administration, even in Obama administration, even Bush administration, even in Clinton administration. Anytime when you are coming after 180 days, there is a chance of denial. And I see some of the people, particularly, the elder generation people, where the children have moved in, got their citizenship, and they applied for the parents. These parents don't want to live in this country. And they go and visit and they come back 11 days and 20, sorry, 11 months and 20 days with a written ticket of 1 week going back to India. At that point of time, the CBP may request to cancel the green card because they're not maintaining the residence in United States. So those people definitely should be concerned to stay to contact an immigration lawyer before they come into United States. But otherwise, 95% of the rest of the people don't have to fear. If you're just a regular Tom, Dick, and Harry green card holder, you're just visiting and you're visiting for less than 3 months or 2 months, you absolutely don't have any problem.
All right, next topic, FDNS site visits. Are you hearing about more of these happening?
Absolutely, Emily. A lot of FDNS visits right now. And there is, as you already know, Emily, that there is a change on January 18th of the FDNS rules and regulations, especially on the H-1B regulations, have been changed on January 18th, 2 days before the Trump administration came into effect. was that for FDNS is now a mandatory. Previously, it was optional. So if FDNS comes in, you can say, well, your website says it's optional, so it's optional, so we don't have to answer the question. Right now, it has become mandatory, and the expansion of the FDNS has gone very much, and we do a lot of FDNS visit. And when the FDNS is coming, though, they're not only asking the question about the present employer, Emily, they're also asking about the previous employer. Let's say right now you're working for Apple, and previously you were working with ABC Consulting Inc. They're also asking questions about ABC Consulting Inc. and also the Apple or whichever company they are working in. So people need to prepare about their people need to prepare the questions and answers what they're going to ask. What typically they're going to ask, Emily, is that how long you've been employed, have you paid any money to the employer, where were you employed, who is your end client right now, and who is the supervisor that you are. They're also asking if you actually worked at that end client location, if you can show any of the documentation that you worked at the end client location. So if I normally will tell people that if you keep the H-1B petition that you have been filed with the different companies, let's say company ABC filed, and right now Microsoft or whatever company that you're working filed the H-1B, keep the H-1B petition with you. Look into the petition, what your job duties are, where you're working at. If those are in line and your paychecks are in line, I don't think so you will have any problem in responding to the FDNS. But if there is any discrepancy, for example, if there is in-house project and you never work in the in-house project, or if there's an end client and you never work with that end client, definitely you may want to check with the immigration lawyer how to respond. Even before the FDNS comes in, it's better that you check with an immigration lawyer, though. Have you seen
Yeah, and
any odd cases in FDN assembly?
we definitely see cases where they're just asking too many questions that have nothing to do with this person's employment. I mean, the whole purpose of FDNS is to look for fraud and abuse in that particular H-1B petition that was filed by a particular company on behalf of a particular beneficiary. So I have no problem with them showing up at that office location, asking, what are your job duties, asking to see a supervisor and confirming, and where are you working, and, even pay statements or W-2s are fine. But then they go into, how did you get this job? Who did you interview you with? Let me see your bank statements. Let me see your driver's license. All these things that have nothing to do with whether there is a bona fide job at that work location and whether you're complying with the terms and conditions of the H-1B petition. So I think as a company, as an employee, it needs to be decided how much information you're willing to share, and at what point you say, I don't think this is relevant to this inquiry, and we are choosing not to respond to that, or refer them to your immigration attorney as well, because you can have an immigration attorney respond on your behalf. But they are many times just turning into a fishing expedition, and a lot of times we're seeing problems when this fishing expedition, the information they get is misconstrued or misinterpreted, and they say something completely different. It's like playing a game of telephone where the employee says one thing, the officer writes down one thing, and then the person interpreting it at USCIS at the service center writes down something else in an actual notice of intent to deny or intent to revoke that is not what happened at all. And now you're having to deal with responding to that in a very quick time manner, because notice of intent to deny or revoke are only given 30 days to respond. And that includes the time it takes to get it in the mail and send it in the mail. So they definitely need to be taken seriously, but also be aware of how much information you're giving, and is it really relevant to the purpose of the FDNS site visit.
But if somebody is getting FDNS, Emily, does it mean that there was something wrongdoing by the employer and employee, or it can be random?
They are random. I think under prior administrations, there was more of a focus on third-party placement. So those working at client sites and consulting companies. But other than that, they are still random for the most part. And so it can be anything. They're just randomly picking. Usually it's after the petition has already been approved. And they're double checking what was stated in the petition to make sure that that's what actually is happening in reality.
So having a petition in front of you guys is always better when responding to it. Just read the employer letter, look into the LCA, where the job postings are. And if by any chance you are working at a different location than your location, for example, if your job location on the LCA is in Florida, you are working in Dallas, you definitely might be in big trouble though. Now, if you're working in Dallas, but then if your LCA is in Dallas, you're working in Irving, which is within the same MSA, then it's not a problem. You're fine with it. You don't have to panic. But if it's Florida and you're working in Dallas, that definitely is an issue. Anything else, Emily, before we go to the next topic?
All right. Yeah. Next topic. Switching employers when you're on an H-1B visa. What should people be aware of?
Emily, previously we used to say, hey, you can switch based on the receipt notice. You can go switch from company A to company B. Especially if you're going from one consulting company to another consulting company, definitely I want to be a little bit more cautious. It's probably worth for you to pay the premium processing fees, guys. We don't make money on premium processing. It's the immigration that makes money. And in our office, so we don't even charge any extra money for premium processing when we file it along with the H-1B. So it's not that we are making money, and we would like all the cases to be decided in 2 days. Definitely, we would like if you want to move to company B, though, you may want to get the H-1B approved in premium processing. And once the H-1B is approved, you should move into the new company. That would be a better way. But one thing everybody needs to understand is that where is your I-140 though? Perm, and don't ever forget that if you don't file a perm and I-140 though, you may be at risk because right now, just to file the perm, it takes about 1 year. By the time you get a perm approval and I-140 approval, it may take 2.5 years. Previously, we told that it used to take 1 year. Previously, we used to tell that it was 1.5 years. Previously, we used to take 2 years. Right now, we're telling 2.5 years. And it doesn't look like the time to and get the labor and I-140 approved is going to come down in the next 3.5 years. It doesn't look like at all. So definitely, we recommend that get an approval and then move to the company B and look into focus into is your I-140 approved? If is more than 6 months the I-140 is approved, these things you need to consider very seriously because if the labor certification is in there and then it's about to get approved, now you're moving to a different company, not a right time to move to a different company.
Yeah, and I would also say do your due diligence on the company that you're looking at transferring to. Obviously, there's household name companies that should be well known and have a good reputation for following immigration laws, but there are companies out there that do not. And so you can look at the H-1B data hub, look at the employers, look at how many H-1Bs they're filing every year, look at how many denials they've received every year, look at what addresses they're listing on their LCA, look it up, Google it, and see, is this an actual address? Because some of these fake companies are listing their address as just a PO box at like a UPS store. You can figure that out just by doing a little bit of investigative work before you put your career and immigration life in the hands of this company that you know nothing about, and just hope and keep your fingers crossed that everything's going to be fine. Not all companies are made the same way. Not all of them are following the law. So just be very careful when you're choosing that company and don't get desperate. If you are nearing the end of your 60-day grace period, that doesn't mean you have to choose any random company that is willing to file something for you if you pay for it, which is not allowed, or says that we'll find you a project later. Just go ahead and file it. No, don't do that. File a change of status to B2. Buy yourself 6 more months. That gives you plenty of time to actually go through the job search process and find a good company to transfer to.
Yeah, and if needed, though, you can always move on to F1 visa. Of course, not the day one CPT, F1, the regular F1 CPT. And if you have an option of H4, go into H4. Don't go to the company if there is no project. I mean, if there is a job there, if they're filing H1B, that makes sense. But if you lost the job with a good company and you are moving to a different company just to stay in the status and they're going to file without a project, no, 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 you do not do that. You have alternative options moving into H4, if not B2, and if not F1. These are options that are there. Don't move to company with a not a project with no job and you're paying the money to the company to run the pay stubs. That is a big no. Recently, we have a lot of people who got into trouble where their green card was being denied because in 2014 or 15 they paid the money to the spouse to file the H1B for the spouse. That was done in 2014, and now the green card is being denied right now. We have had situations where people have been barred completely because it's a misrepresentation, because you have given money to get a fraudulent immigration benefit. You will be in big trouble. Believe me, guys, we sometimes do represent employers too. And when we do represent employers, when we go to the immigration, we give all the information to them. Here is all the people this particular company has did fraud. And then your name will be in there, you're gone. I mean, that happens. And now, of course, we don't represent those companies filing the H1B. When some prosecution happens, then they take our help. At that point of time, we do. We know ins and outs what immigration does. At that point of time, they disclose all the information that you paid the money. And we know, and they will submit it. They will ask, where did they pay the money? They paid the money in India to his cousin, and that cousin, what they did, we don't know. They have all that information because when these people get caught, they give all the information so that they don't have to go in jail for a long period of time. That's how they protect themselves, by sacrificing you. So you do not file the H1B unless there is a job. You do not pay any money. If the company is charging you any money, that's definitely a fraudulent money. The only money that is allowed for you to pay is the premium processing fees. Anything else, Emily?
All right, I think we can go to the questions.
I want to give some updates, Emily. One of the main thing was what you pointed out is not to file the H1B with these companies, but I also want to give a couple of different updates what are going on. If there is a DUI, we are noticing STEM extension denials nowadays, though. That is happening. That is happening quite frequently. Initially, we thought it was only one or two that we are noticing the denial. Can you explain that more, Emily? How that
Yeah,
is?
so the I-765 application is the form that you're filing to apply for a work permit, an EAD. So if you're an F1 student, that's what you apply to get your OPT or STEM OPT. And in the regulations for employment authorization, it very clearly says that this is a discretionary benefit, meaning that USCIS can use their discretion to approve or deny it. So most of the time, it's a very straightforward run-of-the-mill application. For a STEM OPT, you show that you have the STEM degree, you show that you graduated, you show that you have the I-20 authorizing the STEM. You give your employer's E-Verify account number, and they verify all of that. And if all looks good, they approve it. But now under this discretionary provision, we've started to see that they're doing more background checks into the applicant and saying, wait, we see arrest record, we see a DUI. In that case, we are intending to use our discretion to deny your EAD card simply for that reason. And when it's discretionary, it's very difficult to overcome that. So some of the prior cases we saw, these discretionary denials were just straight denials. We were not given an opportunity to respond to prove that in your discretion you should approve this OPT card, for example. But some of the recent ones we've been seeing are an actual notice of intent to deny on the grounds that they want to use their discretion, and they're giving the opportunity to respond. So that is somewhat good in that now we have the chance to explain the situation, how long ago it happened, how the person has recovered from it and all of those factors that would be a positive to show why this person should receive that EAD. But it's definitely something to watch out for anyone applying for an EAD.
Um, let's go to questions and answers. Question from Sarato Julio. I got an H4 visa, but I have the H1B I-797 approval, and that most probably does not have an I-94 attached to it because you're outside the country. Can I enter into the country using the passport visa stamping on H4? And at the time when you enter into United States, can I show the H1B and enter on H1B? The answer is clearly no. You have to get a stamping. There are other options is that you can come into United States and then you can apply for a change of status to you can apply the change of status to H1B once you enter into this country.
Ram said received green cards in May 2024, visited India in July 2024, and now his wife and U.S. citizen child are traveling to India in May till July of this year. And he wants to know, are there any re-entry issues for her? None that would be expected. She's staying for less than 6 months. She lives in the US. She's temporarily traveling to India. I'm assuming she doesn't have a criminal background. I'm assuming she's not, supporting any terrorists or that sort of thing. So she should be fine to take that trip and return to the US.
Rajiv Mishra, I got a residency. Can I transfer my H1B from one hospital to the residency hospital? Absolutely, yes, you can. But however, you need to be a little bit careful, Rajiv. If you don't have an I-140 approval, though, will you run out of the 6 years of the H-1B? That's something that you may want to look into. Sometimes it may be advantageous to take a J-1 visa for this residency program rather than H-1B because you can save some time on H-1B if you don't have I-140 approval. And there are some ways to get around the J-1 visa waiver where you can go and work in the rural areas. And they are exempt from H-1B. There are a lot of things you may want to consider the J-1 visa, but you may consult an immigration lawyer to make a wise decision because that's going to affect a long-term effect. And there are some places if you go to H-1B, there are some places if you go on a J-1 visa.
Goldston says, what is an RFI during the perm process? Is it the same as an audit? And if they're different, how long does it take? It is not the same as the audit. An RFI is during the prevailing wage determination. So the first thing you do with the perm process, once the job description is determined and what the minimum education and experience requirements are, is you submit a prevailing wage request asking the Department of Labor to tell us what is the prevailing wage for this job in this location based on the job duties, minimum education, experience requirements, special skills, supervisory attributes, travel, all of those things go into a prevailing wage. When DOL receives that, sometimes they're not able to determine exactly what is all the details that they need for issuing that prevailing wage. So to issue the prevailing wage, they need to know the exact work location. They need to figure out what is this actual occupation so that they can fit it under the correct occupation code. And then they need to decide what is the wage level, 1, 2, 3, or 4 that's most appropriate. So sometimes they get confused about what the employer submitted and just ask for clarification. Now, sometimes they ask for clarification on things that we've never needed to clarify before when we've been using the same terminology for the last 20 years and they understand what it means and they've always issued the prevailing wage a certain way. Now, all of a sudden, they're issuing an RFI on half of them saying, we don't know what this means, explain it in more detail. So it's normal. We definitely have noticed an increase in them. It does add some extra delay to the issuing of the prevailing wage, but not a ton because employers are only given a short window to respond to the RFI. I think it's only 10 days, if I recall. And then we're usually seeing the prevailing wage issued shortly thereafter, maybe within 2 weeks. So it might add an extra month to the ability to get the prevailing wage. But it's definitely not the same thing as an audit. The audit is after you filed the perm and they're asking you for all of the recruitment records, all of the people who applied for the job, all of the reasons why they were not qualified for the job, all of the advertisement to show that they were actually posted in the right place at the right time. And so the audit definitely is a bigger process and takes a lot longer.
My case is pending with NVC, waiting for the interview to come. But due to ban on Afghanistan, will it affect the process? Absolutely, it may affect the process. Especially if you are, if the case is in Afghanistan, it may affect. This is from Nasibullah Mir. Question from Wink. I have a job loss and he's considering joining an in-house project with a consulting company. I would definitely strongly recommend to consult an immigration lawyer before you make any decision, though. Emily, one thing I want to discuss with you, which you and Stephen had some discussion yesterday, on the G325R. I had so in the as you know that now the administration want all the people who are 14-year-old plus who are legally in this country, they want them to be registered. And I have written an article. You can go to rnlawgroup.com. We put a separate YouTube for that. You can look into that one. That's just there 2 weeks ago. We put our 1 week ago we put it, and the link is there. But a couple of people complained to me, Emily, that it doesn't give an option other than how did you enter into the country, though. I feel that, but I forgot it when you were discussing with Stephen. It only gives EWI, that means entered without inspection option, which none of our clients have been. All these kids are. So I had a Zoom call with this gentleman. In the regular Zoom call, he came in. I said, let me do the Zoom call. I want you to share that. There is an option in the EWI, Emily, that they can leave it blank, either EWI or leave it blank. So you can leave it blank instead of putting, don't put EWI, guys, man, that may invite trouble for you. Just put blank there in the G325 form, and the directions are being given. It's there on rnlawgroup.com. Any comments on that, Emily? Initially, you said that some fake news or something, but I checked it. But
Right.
I
Yeah.
checked it.
Because, yeah.
It didn't give me an option. It's just EWI or none. It doesn't give H4 or any option though. So just leave it blank, that one. Don't keep, and you can still continue with the form G325R.
Yeah, so this is specifically under the question that says immigration status at last arrival. So it asks, when did you last arrive to the US? You have to provide your date of arrival, your place of arrival, the date that that status expires, and then what was your status at that last arrival. And the only option is entered without inspection, which is not true, or none. So please just leave that blank and list none, since they did not provide an option for all of the different visa categories for people that did enter with inspection.
How do they make these forms only for?
I know, that's what Stephen and I said. Like, can they not just copy the drop down from the I-539 form that lists all of the different statuses? But then we thought, well, we don't want to do that because they don't even have H-1B on that one. They make everybody pick H-1B1. So I don't know what these people are. They need some guidance on how to create a form, apparently.
Bahama Trip has an interesting question. He has an advance parole that is valid until 2029. And his EAD is expiring in April of 2025. He filed an EAD extension. Of course, he is in adjustment of status. Can he travel right now when the EAD is not approved, but his advance parole is valid until 2029? Absolutely not a problem for you to travel. You will have no problem. Just carry the EAD, carry the receipt notice of the extension. Don't show it to them. Only show the advance parole. Just in case if they ask any questions, you can show, but you will have no problem, none whatsoever at all, for you to travel and come back in advance parole.
Let's see. Unconventional says that travel bans may actually benefit Indians because it'll increase green card availability and potentially accelerate priority dates. Maybe. I mean, we definitely saw that before when the immigrant visa ban, because a lot of immigrant visas are family-based green cards, and they were blocked from being issued at consulates. That meant those went unused for the year, and then the following year, those go to employment-based. So yes, there is potential for that, but you also have to look at what countries they're issuing a travel ban for. How many immigrant visas are typically being issued for those particular countries in any given year? I think the number is quite small, whereas before the immigrant visa ban was worldwide. The entire world, nobody could get a green card at a consulate. And so, yeah, that definitely impacted the number of family-based green cards that went unused. I don't think this will have that kind of impact. And then even if it does, and they do accelerate those priority dates, remember, just because they move the dates and we have double the number of green cards available doesn't mean USCIS is going to process them all. We saw that happen before. They wasted 80,000 in 1 year. Those dates could have moved even further forward, but they couldn't because they didn't have the efficiency to actually process the green cards that were available in that year. So sounds like a good idea, but I don't think in reality it will make much
A lot of
difference.
questions with regards to the birthright thing. Eventually, it will be decided by the Supreme Court. Now, there are a lot of lawyers who will disagree which way the decision is going to go. But there is one thing that every lawyer in the United States agreed is that this case will be decided in Supreme Court. Now, what will happen to the children who are born from February 19th until the Supreme Court decision? Will they get it? Will they not get it? Now, there are a couple of steps that what you can do, guys. Because right now, there is an injunction that means that they can't enforce it. If the child is born right now, I want you to do one thing: get the birth certificate, get the passport, and do not get your country citizenship. That means, let's say, for example, you're from India. There are ways where your child can get Indian citizenship and Indian passport. Don't get that. Don't get that one. Try to get the birth certificate, get the passport as soon as possible. But of course, if they don't allow it, though, that's a different issue. But as of today, that is March 18, 2025, they have to give the birth certificate, they have to give the passport. And not only get the birth certificate, I want you to apply the passport, because who knows what the Supreme Court is going to make a decision. For those people who already got the passport, they get the citizenship. And for those people who did not get the passport, won't get the citizenship, then we'll be in trouble, is that right? So that's the reason I want you to apply both the things ASAP.
Vin says, in case of job loss when we have a pending adjustment of status, can we join a consultancy firm on
I
a so-called
I had
internal
this.
project to
I
avoid
had
an
this written.
employment gap?
Yeah,
You
yeah.
already got that one. Oh goodness, yeah. Okay. My spouse, Abby says, my spouse got the H4 denied, but the EAD approved. The reason for the denial was she used automatic visa validation and
That's
traveled to
good.
Mexico. Will there be any issue in stamping or re-entry or the green card process? No, not at all. She already has the H4, so that's why they didn't give it to her. So now she has the EAD. She got the automatic extension of the EAD. Now the EAD is approved. There's nowhere where you have to disclose that the H4 was denied. It doesn't. In the DS-160, when it asks, have you ever been denied a visa? The answer is no. An I-539 application is not a visa. When they're talking about visa, we're talking about the stamp in your passport. Were you denied at the consulate after you've applied for the DS-160? That's what that means. Have you ever violated your status? No, an H-4 denial is not a violation of status when you already have an H-4 approval issued by CBP. So no worries at all.
Gentlemen, his best friend Log from YouTube has this question. I have an EB3 I-140 approved in 2015. Now the company is doing EB1C category. Most probably he left the country and worked for 1 year and came back. Are there any pitfalls? What pitfalls? It's good for you, good for everybody. There's no pitfalls as long as the documentation is very clear, because you can't contradict the documentation once you say something. So that as long as you're eligible for EB1C, and absolutely, that is the best option that can be done. I've seen a lot of people who have companies, they have moved them back to their home countries and sometimes to Canada, moved them back to USA, and then did their EB1C approval. One of the companies, namely, that did a lot of that, where I've seen is Amazon, that is doing that kind of job. So absolutely, that is very good option for you, best friends.
NVK says, as there's been movement in EB2 India, do you foresee EB2 reaching December 2014 by next year? I believe many green cards have already been issued to 2013 and 24 applicants. I don't think so. Yes, there's a little bit of movement that happened recently, but based on the numbers that we had, now the data is a little bit old. We're thinking it will be 2030 by the time we get through December 2014. So we got another 5 years to go. Now, we don't have recent data on the number of 485s issued to people from India in EB 1, 2, 3, all that data is not published as quickly. So we don't have that information. We do know, I think, I looked it up. So far, we have the number of 485s approved in October, November, December, and January of this fiscal year. Total employment-based green cards is 37,000, and we have 150,000 available. So in those 4 months, they've issued exactly 25% of the green cards available, which is what they should do because that's a quarter of a year. So they're on track. They are approving them on time, but there are a lot of people in line between now and December 2014. So I don't think it'll get there next year.
Raj has his passport already stamped with, I'm assuming, H1B until 2026. Is it safe to travel? The answer is yes, but he asked a second question. Do you have any concerns for the port of entry into Abu Dhabi? I hate Abu Dhabi port of entry. If you are an Indian, Abu Dhabi airport is not for you. They hate you there. If you're an Indian, they hate you. I don't know if it's a legally viable word to say or not, but that's how they have behaved. So definitely, if you can avoid Abu Dhabi airport, that would be better for you.
Ganesh says, what if we're working from home on that day that an FDNS site visit happens in the office? Do they call HR or a manager? So it really just depends on that particular officer. In many cases, they come and visit the company and they talk to the person that signed the petition or the manager or whoever answers the door. They talk to the receptionist. If the receptionist says, I have no idea who you're talking about, that happens sometimes, and that turns into a notice of intent to revoke. It's crazy. So sometimes that happens, and then if they're coming to actually speak with you and you're not in the office that day, they sometimes will send an email or they will talk to whoever will talk to them at the office to verify the information. It just depends on the officer.
I have been laid off, and my H1B process of stamping is there. It's in the administrative processing. If they call me to send the passport, should I give the passport for them to stamping? No. Right now, I want you to withdraw the passport stamping. I want you to send a letter to the consulate saying that I no longer do have the job, so please withdraw that. I'm withdrawing this visa application because that's going to be very negative if you don't give that information.
Banty says, I've started a single member LLC on H4 EAD. Do I need to e-verify the LLC? Maybe, but probably not. So e-verify is a way that companies can voluntarily join this system so that when you do your I-9 process, when you hire a new worker, so every time any company, whether it's an LLC, corporation, S Corp, C Corp, sole proprietorship, every single company in the United States, when they hire anyone, regardless of whether there's a citizen, green card holder, EAD, asylum, refugee, H-1B, F-1 OPT, every single time you hire someone, you have to fill out an I-9 form. The purpose of the I-9 is to verify the employee's identity and verify that they are in fact authorized to work. E-Verify is an electronic version of the I-9 form that verifies that this person is actually authorized to work based on the information that you enter into the system. So it is mostly a voluntary system. Unless you are involved in government contracting, some companies are required to be E-Verify companies. There are some states that might have mandatory E-Verify requirements, but for most companies, no, you don't need to use E-Verify. It's a choice. You can use it. Now, the benefit of using it is that if you enter someone's information into E-Verify and it comes back and said, yes, this person is authorized to work, we verified, it's great. And then 3 months later, ICE shows up and says, hey, this person's here illegally. You're kind of in a what we would call a safe harbor because you entered their information. The government confirmed that it was correct. You can't be held liable for relying on what looked like genuine documents because you don't know if that person stole someone else's identity. You can't verify everything, and you're not expected to be a document expert. The other benefit of E-Verify is if you want to hire F1 students who have the OPT STEM extension, the only way you can do that is if you use E-Verify and you complete the I-983 training plan for that particular student. Now, be aware, once you join E-Verify, you have to use it for every single employee you hire from that point going forward. A lot of people get confused and think, well, I joined E-Verify so I can hire this STEM OPT worker. So I only have to E-Verify this STEM OPT worker. I don't have to do it for anybody else. That's not true. You have to do it for every single employee going forward. So it's definitely something you need to speak with either an immigration attorney about, an employment law attorney, or a business attorney about whether it's the right thing for your company and whether it's a good idea to do that or if you're required to
If
do it.
people who have got the visa after they turn 14 and they have done the biometrics, they don't have to fill the G325 or it's only those people who came into United States, then they become 14. We want them to go and register on the G325R. And some of the people, my daughter is 10-year-old, does she need to do it? No, when she turns 14, we want you to do it. S3 Glitters has this suggestion that Abu Dhabi people, they take Indians to the extra checking and the treatment is not so good. And believe me, guys, Abu Dhabi, they hate Indians. They don't like Indians. I don't know how to say avoid that one. It just costs $100 here and there. It is not worth for you to save that $100 to go to that airlines.
Kirti says, how do we get experience letters from my previous employer legally? There's no legal requirement that an employer has to provide you with an experience letter. So it's just a matter of you asking for it. And if they say no, it's against their policy, there's nothing you can do to force them to give you an experience letter. That being said, you can use secondary evidence to prove your experience, like your pay statements, like your offer letter that has your job title on it, like your W-2s, and then affidavits from former coworkers who can confirm what your job duties were during that time and what dates you worked for the company.
Question that is coming from Sudhakar. His H-1B extension, should he file in premium processing? One thing is that if you want to get, I want you to get the results of the H-1B before your current I-94 expires. Let's say, for example, your H-1B is expiring in September, and it's up to you. You can wait until June or so to see if the H-1 gets approved. Otherwise, I want you to get the result before September, not in October. Because if by any chance denial comes in October, your H-1B is expired in September, and you already know that by filing an extension, you can continue working. But if the denial comes in, then you have to go outside the country, and maybe your employer will terminate your job because they don't want to deal with all these stuff. So get the decision before the I-94 expires. It's worth paying the premium processing. Next question that is coming is for the H4 plus EAD. Same gentleman are asking if you file H1B and H4 plus EAD, are they approving together? I would say 80% of the time they are approving together. It's definitely worth the premium processing. It's definitely worth to club the application H1, H4, and EAD together right now instead of filing it separately.
Venkata says, my perm application was submitted in September 2024, and my H-1B petition is valid until October 2025. That's the max out. Should I apply for the 7th-year H-1B extension in April or May 2025 while my perm is pending? Yes, because based on that timing, it's very unlikely that you're going to get your perm approved and your I-140 approved before your H-1B expires in October 2025. So you could file 6 months before. So that looks like April 2025. You can file to get your 1-year extension because by September 2025, your perm will have been pending for 365 days. That allows you to get that 7th-year
Emily, I have this
extension.
question. I may need your interpretation on this one, though. I want you to correct me if I'm wrong. This gentleman from Prashant Murthy is asking this question, that are there any changes in eligibility requirements or the approval of the EB2 NIW under the new administration? Let me tell you, yes, there is more stricter interpretation in getting the NIWs approved. But let me also answer the questions, though. This is across the board in getting the 485 approved under the adjustment of status, in getting the STEM extension approved and in USCIS, in getting the H-1B extension approved, in getting the H-1B transfer approved, in getting the H-1B amendment approved, in getting the clubbing of H1, H4, and AAD together. Also, previously they used to get approval of all those things. They don't. In every way, the interpretations have changed from the past administration to the current administration. Emily?
Yeah, I think it's definitely getting more difficult to get NIW applications approved. They're looking at everything with more scrutiny, and we're seeing more requests for evidence on it. So kind of the golden days of everybody being able to get those approved seems to have come to an end, but it's still possible to get approvals. You definitely need to work with someone who has guided people through that process and is doing it continuously, so they're familiar with all of the different trends in the adjudications, to make sure that you meet all of the requirements or can advise you on what additional things you can do to qualify for it under the current interpretation, because it is always changing. Even if there's no policy announcement, even if there's no change actually happening, it's all about the interpretation of it, and everything's going to be more strict as we go forward.
Anju Singh has this question that is, if advance parole is expiring in July 13, 2025, his extension is pending. He has an emergency thing to travel to India. I don't see any problem as long as you're coming back before the advance parole expires. I'm not seeing any problem. There were some lawyers on the YouTube. They said that they have cautioned advance parole people. We are not. We have no problem with advance parole. We have so many entries in the advance parole, had no issues.
Vijaya says, I'm on H4, received the extension almost a month ago, but the date has not been updated on the I-94 on the CBP website. How long will it generally take? It will not get updated there. So USCIS is a different agency than CBP. CBP gives you an I-94 only when you enter into the US. Once you file an extension with USCIS, your new I-94 is given on paper by USCIS. That's your new I-94. The number stays the same, but that's your new end date. It does not change in the I-94 website because that's CBP. The only time that is going to change is the next time you travel. When you come back in, it'll be updated after that.
Nafis Shaikh has this question that I got my green card based on the employment. When can I leave the employer? You can leave immediately. Absolutely not a problem. There are a lot of people that have left within 1 month, had no problems, none whatsoever at all, after they get the green card. And will there be any problem for the green card? No. Will there be any problem for getting the citizenship? No, absolutely not required. Absolutely not.
I think we are out of time for today. Thank you everyone for joining us. As usual, remember to sign up for our newsletter by going to rnlawgroup.com. That way you'll get updated with all of our articles that we put out every week and all of the latest news. You definitely want to stay on top of the trends as the Trump administration moves forward with a lot of their plans. And we will keep you updated and hopefully try to calm some of your fears, because there's definitely a lot of things going on in the media that makes it sound like things are worse than they are, or that people should be afraid. We'll try to let you know when it's time to actually be worried. But right now, for most people in employment-based immigration, not a lot of impact with some of these recent cases that have been in the media.
Thank you very much.